On the 29th of July 2024, Axel Rudakubana, having travelled from his home by taxi, perpetrated an almost unimaginable, but nonetheless mercilessly calculated knife attack at a Taylor Swift-themed children's dance event in Southport, attended by girls who were mainly between the ages of 6 and 10, one being 13 years old. For the benefit of the victims and their families, for whom this is an issue of significant and wholly understandable sensitivity, his name is not to be used during this inquiry. He will simply be referred to as the perpetrator or AR. He was just short of his 18th birthday. He murdered 3 of the young girls taking part in the event. He left 8 other children and 2 adults gravely physically injured. An additional 16 escaped without physical injury, but they, like all of those who were bodily wounded, suffered significant psychological trauma. As the government at the highest levels has recognised, the perpetrator is responsible for one of the most egregious crimes in our country's history. However hard we try, ordinary language simply fails to reflect the enormity of what he did on the 29th of July last year. None of the most powerful adjectives even begin to suffice. There are no words adequately to describe what occurred, and I'm not going to try and then fail to find them. Instead, I simply observe that his crimes impose the heaviest of burdens on our society to investigate speedily but comprehensively how it was possible for AR to have caused such devastation, to analyse the decisions that were or were not taken by multiple individuals and organisations given his deteriorating and deeply troubling behaviour, to identify without fear or favour all of the relevant failings, and to make comprehensive, sensible and achievable recommendations to ensure we have the best chance of intervening with and preventing others who may be drawn to treating their fellow human beings in such a cruel and inhuman way. The perpetrator was arrested at the scene. He entered very late guilty pleas to 3 counts of murder, 10 counts of attempted murder, offences of having a bladed article, production of a biological toxin, and possession of a document likely to be useful to a person preparing an act of terrorism. He was sentenced to custody for life with a minimum term of 52 years. If it had not been for his age, he would have received a whole life term. On the 20th of January this year, the Home Secretary announced that there would be a public inquiry. Work started as soon as my appointment was approved on the 4th of April, and the inquiry was formally announced on the 7th of April. It will have 2 phases. During the first, which will occupy us for the rest of this year, we will investigate the relevant circumstances surrounding the attack and the events leading up to it. This will include analysing the perpetrator's history and his dealings with all of the relevant agencies. We will identify the decisions that were made or not made, how information was shared, and the extent to which the risk he posed was addressed along with any missed opportunities to prevent what occurred. This will necessarily be wide-ranging, encompassing the criminal justice system, relevant events during his education, his engagement with social and healthcare, his relationship with his family, and much else besides. During the second phase, commencing and completing next year, we will consider the wider phenomenon of children and young people who are being drawn into extreme violence, determining what can and should be done to reverse this troubling trend. I am deeply conscious that this is yet another public inquiry. The perpetrator's responsibility is clear. Whilst there was no criminal trial, many of the events regarding the attack itself have been established by the investigation leading up to his guilty pleas in the Crown Court. Many ask, therefore, why has the government set up another inquiry, given we already know what happened? I want to address these wholly understandable doubts head-on. Indeed, the Home Secretary herself has stated publicly why this inquiry is of such importance, having emphasised in her speech in Parliament that the responsibility for the attack lies with the perpetrator. The Home Secretary added, and I quote, "The families and the people of Southport also need answers about what happened leading up to this attack. The perpetrator was in contact with a range of different state agencies throughout his teenage years. He was referred 3 times to the Prevent programme between December 2019 and April 2021, when aged 13 and 14. He also had contact with the police, the courts, the youth justice system, social services and mental health services. Yet between them, those agencies failed to identify the terrible risk and danger to others that he posed. How, Ms. Cooper went on to ask, did he fall through so many gaps? There are grave questions about how this network of agencies failed to identify and act on the risks. Answering those questions, with all the complex issues they raise, is the central task of Phase 1. What wider reforms may be appropriate will be the central question for Phase 2. There is, in my mind, absolutely no doubt that the 2 phases of this inquiry are a truly critical undertaking. We need to understand what went wrong and thereafter to identify and implement the most effective measures to ensure, to the extent that we are able, that there is no repetition. As a society, we are not helpless when confronted with individuals who are known to be contemplating acts of such depravity. And although no solution will be foolproof, we can identify all of the robust steps which should be taken to protect ourselves, and particularly the most vulnerable, from horrors of this kind. And this must be undertaken at speed to provide answers for the victims and their families, and to identify all of the changes that urgently need to be made. But I now want to pause before I turn to the remaining elements of this opening, because we should formally pay tribute to the victims and the survivors of this attack. There are 2 critical aspects as to how this is to be done. First, the girls who survived and their parents are protected by anonymity. Accordingly, their names are not widely known and must not be reported. Second, the attack has had deep implications for a wider group of individuals, including those who first attended the scene, amongst whom were members of the public who intervened. I hope that this wider group will forgive me if they are not included when I read out the names of those who were killed and those of the 3 adults who survived, all of whose identities are publicly known. Furthermore, I am acutely aware of the respect that should be recorded individually to each of the anonymous surviving victims. It is for that truly important reason that I intend to read out the 23 ciphers, simple letters and numbers, which we will use during the inquiry in order to reflect individually their equally critical role in this inquiry. The girls who were killed were 7-year-old Elsie Dot Stancombe, 9-year-old Alice da Silva Aguiar, and 6-year-old Bebe King. The 8 girls who were physically and psychologically seriously injured are child C1, child C2, child C3, child C4, child C5, child C6, child C7, and child C8. And the 15 girls who, although not directly physically attacked, were deeply psychologically injured as a result of what they experienced are child J, child K, child L, child M, child N, child O, child P, child Q, child R, child S, child T, child U, child V, child W, and child X. As to the 3 adults, Leanne Lucas, the organiser, and Jonathan Hayes, who worked in the adjacent office, were both stabbed and suffered psychological injury. Heidi Liddell, who helped organise the event, shielded one of the children in one of the toilet cubicles and was inevitably traumatised. As to the second part of this tribute, I now ask all of those who are able to do so in a moment to stand for a minute's silence in memory of the deceased and to acknowledge the ordeal of the survivors, along with the families of all the girls who were present on the 29th of July 2024. Thank you. Let me return to the purpose of this inquiry in a little more detail. Shortly after the announcement of the decision to set up an inquiry, the Prime Minister said, "We must make sure the names of those 3 girls are not associated with the vile perpetrator, but instead with a fundamental change in how Britain protects its citizens and its children. In pursuit of that, we must, of course, ask and answer difficult questions. Questions that should be far-reaching unburdened by cultural or institutional sensitivities, and driven only by the pursuit of justice. I'm not going to read out the Phase 1 terms of reference word for word. They are available on the inquiry website and in the procedural annex that will accompany the release of these opening remarks. I have, moreover, already summarised the approach that is to be taken. I will make recommendations at the end of Phase 1 to the extent appropriate. Some aspects of wider change will fall into Phase 2, but I'm determined to make early practical recommendations arising from the first phase of this inquiry. I need to stress that the terms of reference for Phase 2 have not yet been settled. The Home Secretary has indicated that they will be informed by my findings in Phase 1. But the intention is that Phase 2 will consider the adequacy of the present multi-agency systems when addressing the risk posed by young people whose fixation or obsession with and desire to commit acts of extreme violence presents a significant risk to public safety. It is of relevance, therefore, to Phase 2 of this inquiry that the Prime Minister has unequivocally indicated his wish for it to be far-reaching. He stated, and again I quote, "Southport must be a line in the sand. Nothing will be off the table in this inquiry, nothing. And most importantly, it will lead to change." This inquiry is therefore expected to act as a real engine for change, given the unparalleled nature of what occurred. I am determined it will not turn into an exercise of papering over the cracks. The expectations of the Prime Minister and the Home Secretary have provided, accordingly, the critical context for the evidence we're going to hear relating to the years preceding the attack, along with the conclusions that are to be drawn from that evidence. I anticipate that the essentially undisputed but troubling facts will include the following. First, the perpetrator returned on the 11th of December 2019 without permission to a school from which he had been excluded. When challenged, he ran down a school corridor, raised a hockey stick above his head, and struck a student. He was found to have a knife in his bag. He tellingly stated that he had intended to kill another student. Second, he was referred to Prevent on 3 occasions: the 5th of December 2019, the 1st of April 2021, and the 26th of April 2021, based on each occasion on his online activity, which included research into school shootings, the Libyan military dictator Colonel Gaddafi, and the London Bridge terrorist attack. Third, having been reported missing on the 17th of March 2022, the perpetrator was found by police officers on a bus with a knife, again of potential critical importance. He said he wanted to stab someone. Fourth, he had accessed online books, research papers, information leaflets, and instruction manuals, which included material about explosives, warfare, knives, assassination using poisons and cold steel, and military studies in the Jihad Against the Tyrants, the Al-Qaeda training manual. These were found on his electronic devices after the attack. The Al-Qaeda manual had been downloaded twice, once on the 30th of August 2021 and then again on the 4th of September 2021. Fifth, he managed to obtain, for the purposes of carrying out the present attack, a 20-centimetre chef's knife. Initially, he made and then cancelled this purchase using his own name. Thereafter, he successfully bought the knife using a virtual private network in order to obscure his IP address. Sixth, he attempted to return to the school from which he'd been excluded and where he had carried out the previous attack with the hockey stick whilst carrying a knife, on the day the school broke up for the summer holidays. This was a week before the attack on the 29th of July 2024. Seventh, before he committed the present crimes, he viewed an online video of the stabbing of a bishop and 5 other individuals. And eighth, dating back to at least as early as January 2022 and continuing through to July 2024, he obtained a number of extremely disturbing items which were found when his home was searched after the attack, some or all of which had been ordered online. A bow and arrow, 2 different types of machete, knives with, respectively, 20-centimetre and 14-centimetre blades, a sledgehammer, materials that could have been used to make Molotov cocktails, and substances that were used by him to make ricin, which is a lethal toxin. I should emphasize that I am acutely conscious of the need not to prejudge any of the matters which I need to determine in phase 1 once I have heard all the evidence. But these factors, if correct and when taken together, tend to suggest that far from being an unforeseeable catastrophic event, the perpetrator over a number of years posed a very serious and significant risk of violent harm, with a particular and known predilection for knife crime. Furthermore, his ability, unhindered, to access gravely violent material on the internet, to order knives online at a young age, and then to leave home unsupervised to commit the present attack, speaks to a wholesale and general failure to intervene effectively, or indeed at all, to address the risks that he posed. This inquiry will, therefore, scrutinise with care the actions of those involved in responding to these events and the threat posed by the perpetrator, without simply being wise after the event. Was the response and assessment of risk sufficient? Was information properly shared? Was the understanding of the risk kept up to date? In recent years, there have been a number of fatal attacks examined by major inquests or inquiries, during which the multi-agency handling of risk, including but not limited to the PREVENT programme, has been repeatedly questioned. Given this continuing theme, I will necessarily need to reflect on whether our country has in place the mechanisms to enable effective intervention in cases such as the present. The state's well-established countermeasures against terrorism are, of course, vital. But does that machinery adequately address young people who are drawn into extreme violence without an accompanying commitment to a particular religious or political cause? Put shortly, should there be more effective mechanisms for identifying those who are contemplating serious offences, for monitoring their behaviour, and for controlling their activities? To summarise, therefore, the central purposes of this inquiry is to look at what went wrong leading up to the 29th of July, phase 1, and to make immediate recommendations, and in phase 2, to address in a critical, open-minded review the profound and difficult questions that are raised by what happened, adopting the Prime Minister's nothing-off-the-table approach. There will be many areas that, at least potentially, will benefit from change. I want at the outset to identify 3 in relation to which I will require particular assistance. First, the present Crime and Policing Bill has passed its second reading in the House of Commons. It will, amongst other things, create youth diversion orders which are aimed at those under 21 involved in terrorist offending, in order to, open quotations, divert them from the wider criminal justice system, close quotations, including prosecution. The present offences were not terrorist related. A question therefore to be answered during the inquiry is whether the state should have the capacity to impose restrictions on an individual, those both above and below the age of 22, when there is strong evidence that they intend to commit serious violent crime, but have not yet taken steps such as to justify their arrest or prosecution, whether their actions were terrorist-related or not. If a sufficiently strong risk is established of an intention to commit an offence of serious violence, should the courts be in a position, for instance, to impose a curfew, require a tag, otherwise limit their freedom of movement and their ability to carry out research on the internet and to use social media, and to require psychological intervention until the risk has sufficiently been alleviated? Or would such a development run counter to the basic underpinnings of our democracy and our core civil liberties? Second, I was the judge coroner in the Forbury Gardens inquests, which concluded on the 26th of April 2024, when I published my factual findings. I was greatly concerned in that case as to the adequacy of the arrangements for sharing information, along with the mechanisms for assessing if an individual posed a substantial risk, which, if they'd been operating correctly, would have enabled necessary preventative steps to have been taken. As in Forbury Gardens, the question inevitably arises in the present case as to whether, when a number of agencies are involved, the correct procedures exist to enable the proper analysis of all the relevant information and an appropriate and effective response. I raise additionally, and for me significantly, the question, when multiple organisations are involved, as to whether a single appropriately qualified official should have the responsibility of assessing what action needs to be taken to ensure serious violence does not occur. One person, one mind, reviewing all the information and then discharging the duty of deciding on the totality of the facts what steps, if any, need to be taken. And I stress, having of course consulted with others. Third, the perpetrator was able to purchase the weapon he used, along with other potentially lethal items, without apparent difficulty online. This regrettable phenomenon is being addressed, but limited to bladed articles and crossbows, in the Crime and Policing Bill now before Parliament. I wish to investigate whether these and any linked provisions sufficiently restrict purchases of this kind, either generally or particularly by individuals who've been identified as posing a risk of causing serious harm. I would benefit from detailed written submissions on this issue, given the ease with which the perpetrator armed himself. Is there more that should be done? I turn next to some important themes of this inquiry and the ways in which witnesses and organisations can exist, along with my frankly expressed expectations of them. The first relates to the duty of candour. Whilst it is not yet enacted into inquiry legislation, the duty of candour on those involved in public inquiries is a well-established principle. The inquiry team has emphasised this from the very outset, as when the solicitor to the inquiry wrote initial letters to all relevant organisations, making it clear that the chair would, I open quotations, expect all those involved in the inquiry to approach the provision of evidence with candour, being reflective and honest about what went wrong, and constructively contributing to the identification of practical and timely improvements that can be made. I want to stress the importance of this principle in relation to individual witnesses and each of the organisations. The expectation is that you will each freely volunteer information about errors and weaknesses. You will highlight the relevant documents, and you will ensure that the evidence which is submitted includes a mature evaluation as to what happened, identifying those things which need to be changed, implemented, or otherwise improved. Witnesses and organisations who comply with the spirit of this approach should understand that I will not thereafter permit point-scoring questions as if this is an adversarial trial. As I have already indicated, the inquiry will hold individuals and organisations to account, but these are not civil or criminal proceedings. The hearings will be respectful and inquisitorial. I therefore expect cooperation, and I acknowledge and express my sincere thanks for the fact that the inquiry team has to date received just that. But witnesses and participants should also be clear that I will not hesitate to use all the statutory powers available to me, as well as the opportunity provided by the inquiry hearings in September and October, to challenge any instance where that necessary cooperation is not forthcoming or when witnesses are not being frank. But I emphasise that the inquiry team has thus far held constructive meetings and discussions with all the key participants, and I am greatly encouraged by the reports of the progress that has been made. The second theme concerns the vital issue of the risks of further trauma for the victims and survivors, and particularly the children. This is a critically important issue for the inquiry's work on Phase 1. A unique feature of the Southport attack is the young age of the child victims. The majority, who I've already said, were aged 10 or under. I stress once more that this is not a trial, and I sit as a chair and not a judge. As might be expected, my immediate priority following my appointment was to organise a series of visits and meetings in Southport in order to meet the victims and all the families. As a result of what I learnt at those meetings, all the participants in this inquiry and the media who report on it need to understand my profound concern as to the very real risk of the re-traumatisation of the victims, and especially the young child victims and their siblings. The surviving girls are all, without exception, bravely trying to cope with school life in the face of what they have suffered. They are constantly exposed to media and social media reporting of the attack and of images of the perpetrator. Their teachers and parents have to take significant protective measures whenever there is a surge in reporting. I believe this places an obligation on me as the chair, on the inquiry team, on the core participants and their legal representatives, and on the media and others who report on this inquiry to reflect deeply about the impact of these hearings and the reporting of them on these extremely vulnerable girls. Our procedures will be adapted to take into account this serious risk of further trauma in 3 areas, and the 3 headings are: first, protective measures including anonymity; second, the content of the public hearings; and third, the public nature of these hearings and the media reporting. I take these each in turn. First, the protective measures. The surviving children's identities were protected by the reporting restrictions which were made during the criminal proceedings. Those orders remain in effect, and they bind this inquiry, including in the reporting of our hearings. This covers all reporting by traditional media, by social media reporting, and anyone posting online. Let me be absolutely clear. No one may post or publish the names of the surviving girls, nor any detail that could lead to their identification. That includes details such as their schools, their appearance, the names of or details concerning their parents or other family members. There are restrictions equally as regards the identities of the siblings of the deceased. Having given all concerned an opportunity to make representations, I have decided to go further for these inquiry hearings in that the surviving girls and their families are granted complete anonymity, such that their names will not be used at any stage. We must all strive with the utmost care to use the allocated ciphers which I read out earlier and not their real names. But if a slip is made, the names and any other identifying details must not, under any circumstances, be reported. Copies of the orders I have made are on the website, and hard copies are available today. An infringement of these provisions will be treated extremely seriously, and I do not have to repeat that I have extensive powers in this context. Second, the content of the public hearings. When the inquiry is dealing with the circumstances of the attack, I intend to limit, indeed to avoid, largely, if not entirely, any evidence concerning the nature and the extent of the injuries to each girl. I'm also going to restrict the evidence as to the forensic examinations and, in the vast majority, if not all, of the individual cases, the subsequent medical treatment. Final decisions in this context are yet to be made, but that will be the general approach. The essential aspects of this grave event have been established, and they are, save for some of the details as to the exact sequence of the events, undisputed. Nobody, least of all the victims, will be assisted by parading in public the grim detail of the perpetrator's actions. It is, however, my duty to ensure that sufficient evidence is adduced in relation to the 3 girls who were murdered, so as to enable me to record the formal matters necessary for the purposes of an inquest into their deaths, but no more. In this regard, I note that the cause of death of each girl and the fact that it was an unlawful killing is beyond doubt. The need for sensitivity and circumspection is vividly demonstrated by the fact that some of the parents have entirely understandably chosen not to be informed of the clinical detail of the injuries that the perpetrator inflicted. That is a choice on their part that we must all respect. During the hearings and in any reporting, this decision by some of the families simply must not be undermined. Third, the public nature of the hearings and the media reporting. My starting point is that these proceedings will be held in public unless there is a very strong reason not to do so. They will be held here at Liverpool Town Hall, where there is space to accommodate the accredited media and members of the public. There is information on the website for anyone who wishes to make an application to attend in person. The hearings will be transmitted via a live feed to additional rooms within this building. There will additionally be live streaming, restricted as and when necessary, to all core participants, their legal representatives, and the accredited media, in order for the hearings to be followed remotely if that course is preferred. I stress that those engaged in any kind of reporting of the hearings must understand the high importance of following the restriction order and the media broadcast protocol, which both addressed the broadcasting permissions. I recognise that there is a likely strong public interest in the hearings being in public, which heightens the need for responsible reporting. There are particular and acute challenges concerning the balance to be struck between the interest in reporting the hearings and the hearings being conducted in public, whilst limiting further trauma to the victims. Following liaison between the inquiry's secretariat and the media, I have agreed that this opening statement is to be broadcast. The inquiry hearings will commence tomorrow with 4 impact statements. There will then be an adjournment until the 8th of September, when, at the outset, we will continue with the remaining commemorative and impact evidence. The inquiry has liaised extensively with the victims and survivors concerning the first phase, and I have given the families and the adult survivors wide discretion as to how they approach this evidence, including as to its format. Once this evidence is complete, we will turn, albeit relatively briefly, to the attack. In relation to these two phases of the evidence, in order to protect the identity of the victims and to limit further trauma, they will not be broadcast. And I will issue a decision in due course as to whether the hearings concerning preventability should, by contrast, be broadcast. There is an additional matter which has significantly troubled me, which I wish to draw to the attention of the media and to those commenting on what occurs in this inquiry via social media. The photograph or mugshot taken of the perpetrator following his arrest has been in the public domain for a significant period of time. It has been routinely used for reporting on the attack itself and in stories regarding the perpetrator's conduct in prison. It is no exaggeration for me to say, reflecting my conversations with the surviving victims and all the families, that this is for them a terrifying and singularly distressing image. Indeed, seeing the face of the perpetrator, often without any warning, has the potential to be significantly re-traumatizing. Every time this unsettling image is reposted or rebroadcast, those responsible for that take on themselves the risk of causing real distress, thereby disrupting the process of rebuilding broken lives. The inquiry team wishes to work constructively with the media, recognising its important role in reporting on these events and particularly on the systems that failed. But all of us participating in this process in our various roles have a real responsibility for the surviving victims and all the families. I suggest this image, in the context of reporting on this inquiry, serves no credible journalistic purpose and only causes harm. I therefore urge all media outlets, traditional print and broadcast media, and those responsible for online reporting and on social media, to refrain from using it when reporting on our proceedings. And I will consider such further measures are available to me should it prove to be necessary. The third theme I want to address is the pace, thoroughness, independence, and fairness of this inquiry. My terms of reference state, quotes, "The inquiry should aim to provide a final report on phase 1 to the Secretary of State for the Home Department by the end of 2025 or early 2026, subject to reasonable progress on matters outside the inquiry's control. The inquiry should make pragmatic choices as to its methods and procedure to deliver within this timeframe." Close quotations. Anyone familiar with the practical and procedural requirements of a statutory inquiry will recognise the demanding nature of this timetable. I make no complaint about that. I have a statutory duty under Section 17 of the 2005 Act to act both with fairness and with regard to the need to avoid any unnecessary cost, whether to public funds or to witnesses or to others. Both aspects of this duty are important. As regards costs, reporting promptly and adopting procedures which are pragmatic and efficient will assist my important duty of ensuring that the inquiry's costs are controlled. At the same time, Focusing on securing fairness, I emphasise that this is an independent and impartial inquiry. It is established and funded by the government, but it is independent of it. Indeed, I will be scrutinising the actions of government and public sector organisations. It is right that the inquiry moves at pace, but I will be equally mindful of the duty to be fair, and I will not permit the understandable requirement for speed to impinge upon the thoroughness of this investigation. The inquiry team, under my direction, has been working extremely hard in gathering all the relevant evidence from a wide variety of sources, reviewing it prior to sharing it with the core participants, as well as issuing requests for focus witness statements so that we are able to pursue all the lines of inquiry that are material to what occurred. This is a monumental task in this era of electronic material, and a mountain of digital records has been produced. I have asked that further detail of this work is set out in the written procedural annex which accompanies these opening remarks and will be available on the website. It is to be stressed and repeated that the procedural work of the inquiry started immediately following the announcement on the 7th of April, when the solicitor to the inquiry wrote to all those organisations named in the terms of reference, putting them on notice of the nature of what was required. To date, the inquiry has made 51 requests for statements and is liaising with 26 organisations as potential holders of material. This work continues at pace, and a key priority is to ensure there is disclosure to the core participants in time for the hearings when they resume in September this year. In broad outline, in order to meet the Home Secretary's challenging request of me, I have established the following timetable. The inquiry opens this week, 3 months after it was first established, not least because I wanted to provide an opportunity to those who would prefer not to wait until September to give their impact evidence. The weeks of the 8th and the 15th of September are reserved for further commemorative and impact evidence. The remainder of the evidence in Phase 1 will commence on or about the 22nd of September, and on current projections will be completed by the 6th of November. We will begin with the limited evidence necessary to address the attack itself and any relevant medical treatment before turning to how the perpetrator's risk was managed by everyone involved with him. November and December will then be an intense period in which the statutory warning process will be undertaken, and I will write my Phase 1 report. The timetable will be demanding on everyone, but it remains achievable. It goes without saying that the cooperation of the core participants and their legal representatives will be essential if we are to fulfil the inquiry's terms of reference. There is no room for unnecessary delays or for protracted procedural disputes. I have issued minded to notes and other guidance to inform the stages of the inquiry's work. Although I have statutory powers of compulsion, I am trusting in the goodwill of all those involved to help deliver the important work of this inquiry. I would particularly commend to all the legal representatives a collegiate approach, working with the inquiry's legal and secretariat teams to find workable and pragmatic solutions to the many procedural issues that will undoubtedly arise. Save in wholly exceptional circumstances, if difficulties are to be raised with me as chair, advance warning should be given with a sufficient written explanation of the point or points it is proposed should be discussed. I will then determine if a hearing is needed or whether it can be resolved on the basis of written submissions. Precious hearing time is not to be taken up with unscheduled or ad hoc legal or procedural disputes. I stress, therefore, that an early indication must be given of potential problems, since it is extremely disruptive to raise last-minute objections or concerns during the hearings. It is critical that we avoid anything which has the potential to cause unnecessary delays or interruptions. Accordingly, I respectfully remind the legal representatives of their duty to think ahead, thereby avoiding last-minute reactions to looming problems. On that somewhat severe note, that is all I wish to say by way of opening remarks. We will resume tomorrow at 10:30 a.m. for the first impact evidence. Once I have left the bench, can I please ask you all briefly to resume your seats until you are told that the families have had an opportunity to withdraw from the chamber. I thank you all very much indeed for your attendance.